Well, hello everyone, and welcome to this live session dealing with employment law. I'm Lior Samfiru, the employment lawyer, and I am here to answer your questions live, to answer your questions and solve those issues you're dealing with when it comes to workplace issues, workplace law, employment law. Again, I'm Lior Samfiru, one of the founding partners of Samfiru Tumarkin LLP. You'll find my firm operating across Ontario, across British Columbia, and across Alberta. And once a week on Wednesday at this time, I log on here and I take your questions live. You got lots of questions, I know, because I get lots of emails, I get lots of calls at the office, people wanting to understand their workplace rights. Well, right now, you can ask me a question. I'll see it on my screen, I'll read it, and I'll answer it. Maybe it's a situation where something just happened now in the workplace. You've been given an ultimatum, your job has changed, you're not being treated properly. Ask away. Maybe it's something that happened a while ago and you want to understand better what it all meant. Or maybe you're worried about something happening and you just want to be prepared. What happens if your boss walks into your office tomorrow and lets you go? What do? What if your boss tells you that you need to make a decision between a demotion or a relocation? What can you say? How do you respond? Is it even legal? I think you get the idea. On this session, we talk about all these issues and much, much more. So if you're facing a workplace issue, you don't have to face it alone. You can have help, you can have support. I'm here for you right now live. I see questions already coming in. I'm going to start answering them in a moment. You have lots and lots of time. So type that in, hit enter, and I'll see it and I'll read it. Beyond the 30 minutes of the session, if you want to connect with me and my team, it's so easy to do. You just go to employmentlawyer.ca. You see that right here on the screen, right there. Employmentlawyer.ca is the place to go to. When you go to employmentlawyer.ca, phone number is there, email address is there. You can fill out a form if you prefer, and we will call you. And of course, you can also read much more about employment law right there. So employmentlawyer.ca is your kind of one-stop shop for anything and everything employment law. But right now, I am here live. Take advantage, okay? I'm not here live all the time. I'm here now. I'm here with you, for you. So ask your question. I will read it and answer it. And remember, there's no bad questions. There's only answers and solutions. We have very extensive laws across Canada when it comes to employment law. We have very good employment laws, excellent employment laws, in fact. Too many people don't know what they are. Well, you can know what they are. You can find out. Asking your question today gets that done. I'm going to start answering questions right now. As you're listening to me, ask your question as well, okay? Don't be shy. Don't be bashful. Let's make sure you get answers. All right. Our first question came in early today, and that's from Desi T. Desi T says, I am experiencing discrimination, retaliation, and harassment at work because of a workplace accident that happened over a year ago. The company wants to let me go. What can I do? So, first of all, Desi, it is illegal to mistreat you because of a workplace accident. It's illegal to mistreat you if you have a medical condition, if you have either a disability or a long-standing condition. All of that is illegal. You can't be threatened, punished, bullied, anything because of that. That's a violation of several statutes, completely illegal, and it can result in what we call a constructive dismissal. So potentially, by being mistreated, okay, by showing that your employer is treating you badly and they're doing something illegal, you can consider, if you wanted, your employment as being terminated and require the company to pay you your full severance. In addition to that, what you've described could be a human rights violation, could be a violation of occupational health and safety legislation. It's illegal in so many respects. Now, if they want to let you go, we can't physically restrain them. We can't physically stop them. But if they do, you better believe there's going to be legal repercussions, significant ones, in fact. So, Desi, you have two options. Either you can contact me right now so we can discuss this, or you can wait to see whether your employer is going to let you go and then contact me. Either way, we need to connect, okay? Because what you've described, of course, is completely illegal. Your employer can't do any of that if that's what's happening. So you need to connect with me either now or once your employer makes a move with respect to your employment. To connect with me, as I said, very, very easy to do. Employmentlawyer.ca. Again, employmentlawyer.ca, the place to go to connect with me. Phone number is there, email address is there. So, Desi, thank you for asking the question. Next step, again, to connect with me through employmentlawyer.ca. Thank you for that. You see how easy it is, right? Desi asked a question. I read it. Now we have an answer. For those that have just joined us, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and I am answering your questions live about employment law. So let's continue. Next question. This one comes to us from YouTube from Dan. I've been working for a siding company for 10 years and haven't been called back. Okay, I guess you've been put off work. The coworkers are still working though. CRA told my employer that I'm owed 2 days pay for every year I worked. Is that correct? Nonsense. No. So if you've been put on a layoff, temporary layoff, you can treat that as a termination. You're owed a lot more than 2 days per year. You've been there for 10 years. You could easily be owed a year's severance, 12 months severance. So no, CRA's job is not to assess employment law entitlements, just like it's not my job to assess how much taxes you're owed. So no, very common when people get incorrect information from a bunch of places. The other thing that I see often is those working in the construction industry. There's a misconception that if you're in the construction industry, if you lose your job, you're not owed severance. Nonsense. Of course you're owed your severance. You're owed severance as much as anyone, and that severance can be as much as 2 years' pay. So yeah, you're absolutely owed severance if you lost your job, whether you're in construction or otherwise. So Dan, you know what to do. The next step is to call me so I can help you get that severance. You reach me through employmentlawyer.ca. All the contact information you need is right there. So very important question. I get so many of those questions with people in the construction industry. Employers often believe, oh, we don't have to pay anything. We're in construction. We're exempt. Well, guess what? You're not exempt. You are obligated to pay severance. So now you know. And again, employmentlawyer.ca to connect with me. All right, let's continue. Guys, you can ask your questions right now. Don't wait till the last minute. It happened last week again when I was just saying goodbye and 2 questions came in. I couldn't get to them. So don't let that happen. You have time right now, tons of time, in fact. So ask your question right now. You ask it now, you'll be assured that I'll see it, I'll read it, and I'll get to it so you can have your answer. So take your time, but don't wait too long. All right, next question comes to us from, no, that's one, Desi T, where I've answered. Linda has our next question. Is there anything that would allow an employer to not adhere to our employment laws, like a U.S. company operating in Canada? Excellent question, Linda, and the answer is absolutely not. Doesn't matter if it's a U.S. company, doesn't matter if they're based in Europe or in Asia or anywhere else. If they operate here in Canada, they have to abide by Canadian laws, full stop. And what matters is the location where the employee is physically working. So if you're working in Ontario, then it's the laws of Ontario that apply to you. It doesn't matter if the company is based out of the United States. The laws of Ontario apply. So no, there's absolutely no legal mechanism to avoid complying with the laws. Think about it. If it was that easy, everyone would do it. So no, your employer has to comply with the laws. Now, that said, a lot of companies, especially U.S. companies, don't get that. In the U.S., they have very different employment laws. And sometimes U.S. companies think that the same laws apply here, which is not the case at all. So sometimes I need to kind of get involved and give them a bit of a kick in the pants, let's say, so that they understand what their obligations are. But they absolutely have to abide by the laws in Canada or in the province where you're actually physically located. Okay, hopefully that makes sense, Linda. If you have a follow-up question or anything specific that you want to ask me about, I'm still here. You can ask that question right now. Thank you for that. If you've just joined us right now, first of all, welcome. I'm glad you're here. You're listening to the employment law session with me, Lior Samfiru, with Samfiru Tumarkin LLP. And I'm here live answering questions about employment law, just like I've been doing for the last 10 minutes or so. I want to hear your question too. I have stuff I can talk about even without questions. I can talk about many, many things, but it's more interesting. It's better if I get to help you by answering your questions. All right, let's see. Next question today comes to us from YouTube again from Clint. Can you make a claim for constructive dismissal after resigning if you had to leave due to a high stress situation? So you can if you can show that your employer did something wrong. If it's simply a situation where the job is just very stressful and you know what, you say, it's not worth it for me, it's affecting my health, it's too stressful of a job, I'm going to leave and find something else. If you leave in that situation, that's not necessarily a constructive dismissal because your employer didn't really do anything wrong. It's just the nature of the job. On the other hand, if your employer does something wrong, they mistreat you, they bully you, they don't provide you the support you need to do your job, they don't follow, if you have medical restrictions, they don't follow those restrictions. So if your employer is actually doing something wrong, and because of that you leave, that absolutely can be a constructive dismissal. And of course, for those that are not sure, constructive dismissal means that even though you, the employer, are the one that's leaving, the law considers that to be a termination of employment and requires your employer to pay you your full severance. So even though the company's not letting you go, you're the one choosing to leave, the company still has to pay you severance if it's a constructive dismissal situation. So stress in and of itself does not necessarily result in a constructive dismissal, but if the stress is caused by something wrong that your employer did, yeah, absolutely, that could be a constructive dismissal. But the best advice is this: if you think you're in a constructive dismissal situation, don't leave. Don't leave till you call me. Okay? Don't leave first, call me second. Call me first. Let's talk about it. Let's make sure we do this correctly, and then we can get you out of there. Okay? So if you think you're in a constructive dismissal situation, you want to reach out to me. And of course, you do that through employmentlawyer.ca. Again, employmentlawyer.ca. But that's for later. Right now, I'm still here with you answering questions just like I've been doing. And of course, I'm Lior Samfiru, the employment lawyer. Let's see what's next. Next question, I believe, is from Jimmy. Jimmy says, I was forcefully asked to resign, not given a chance to fight it, trapped in the back room, and was not allowed to leave until I sent an email resigning, being threatened with criminal charges. Was also told that if I don't, then my staff will all get fired. Well, Jimmy, this is too serious for me to try to deal with this here. You need to call me, okay? We need to deal with this immediately. And for me to try to give you an intelligent answer here, I would be doing you a disservice, okay? You need to contact me ASAP through employmentlawyer.ca. Let's talk about how we deal with this. If there's criminal charges, allegations, they locked you in a room, I'm not going to be able to do it justice here. Connect with me through employmentlawyer.ca and let's deal with it that way, okay? So looking forward to connecting with you ASAP. All right, let's see. Continue to answer questions. Stevie, welcome, Stevie. Stevie has a question. What is the best way to handle a toxic work environment? Excellent question, and a very important one. Very common situation where someone is dealing with a toxic or a poisoned work environment. So the first thing you need to do is you need to make sure that your employer, whoever the right person is at your employer, knows about it. Okay, you don't want your employer to say, we didn't know, you never told us. Your employer, whether it's the HR person, the manager, whoever the right person is, the owner in your workplace, knows about it. You have to tell them in writing. You can speak to them verbally too, but follow up in writing so that there's no question that you told them. Tell them exactly what's happening. Who's causing the toxic work environment, what's happened, who else knows about it, and all the information that you can. Once you do that, the company is legally obligated to take it seriously, to investigate, and to rectify the problem. They have to, by law. If they don't, that could be a constructive dismissal, depending on the situation. It could also be a human rights violation. It's illegal. So you have to tell them. Now, you may say, well, there's no one to tell because it's the owner of the company causing the toxic work environment. So who am I going to talk to? If you cannot deal with it internally, then we have to deal with it externally, which means you call me. And then we can get you out of there and get you compensated by the company for you having to leave to begin with. So ideally, first step is try to deal with it internally. If you tried and nothing's happened, or you cannot deal with it internally, you call me and we deal with it externally. So Stevie, hopefully that makes sense. Any follow-up, ask me, but that gives you some thoughts here. Your employer must deal with this. If you tell them about it, tell them in writing so that there's a record, okay? If you have a conversation with your employer about that later, follow up in writing, confirming what was discussed. Always create that written record. All right, Stevie, thank you for that question. Great one. Continuing to answer questions here. You see how easy it is, by the way, if you just joined us. you can ask your question about employment law, about workplace rights, about what to do in a difficult work situation. Just ask the question right now. Let me get a chance to help you. All right. James has our next question. James is also joining us from YouTube. Lots of people from YouTube today. That's great. James says, self-employed contract terminated after 11 years because of a 29-year-old criminal record. Never asked if I had a criminal record when hired. So first of all, you're not self-employed after 11 years. I'll tell you that right now. The law considers you to be an employee. You're not almost never going to be self-employed, so to speak, and work for the same company for 11 years. The law makes you be an employee. What does that mean? That means that now, because you were let go, you're owed severance. I don't care about the criminal charge from 29 years ago. It has nothing to do with anything. You are owed severance. And after 11 years, depending on the type of job that you have and your age, you could be owed 12 months of severance, even more, even much more than that, depending on those factors. So that's what's happened here. You're owed that easily a year's pay, maybe more. So the next step, James, of course, is to connect with me and make sure that I get to help you, and then we get to work and get you that severance. Very common situation, by the way, when someone has been misclassified as self-employed or as an independent contractor. The law makes that decision. You can't decide if you're self-employed. The company you work for can't decide you're an independent contractor. The law decides that. So in your situation, after 11 years, yeah, you're an employee. You're going to be owed severance. Hopefully that makes sense. Now, I told James that he could be owed 12 months or more of severance. How do you find out how much severance you're owed if you're let go, if you're worried about being let go, you're just curious? It's so easy to do. You just go on any browser to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. You see that address right there. And when you go to pocketemploymentlawyer.ca, you'll see our severance calculator tool. That's it. That's all you need to do. You click on that severance calculator and you answer a few questions, and it's going to tell you how many months of severance you are owed. You can even calculate that in dollars if you wanted to. It's completely free, of course. It's completely anonymous. No names, no phone numbers, no email addresses are needed. It's just there for you. Again, pocketemploymentlawyer.ca. Click on the severance calculator tool and use it. You may be in a situation right now where you think something's going to come up and the company's going to let you go. Maybe you're seeing the writing on the wall. Well, you need to know how much you're owed. You need to be prepared mentally for it. So go again, pocketemploymentlawyer.ca, use the calculator. If you lost your job, you're staring at that severance letter, you want to know what the real number should be. It's probably a lot higher than what you've been offered. Just go to pocketemploymentlawyer.ca, check it out, and you can contact me if you want directly from there as well. All right, more questions have come in. I am going to continue answering. Next one is from first name, last name. I am a part-time employee. Do I get vacation days off or just vacation paid on every check? If I don't get hours regularly after a period of time, have I been terminated? Company says they don't have employee contracts, only job offers. However, the job offer is 14 pages and it says all the conditions of a contract. So first of all, yes, you get vacation time off if you work any job. At a minimum, you have to get in a given year 2 weeks off. It could be more than that, of course, but it can't be less. Yes, you get not just vacation pay, you also get vacation time that you can take. Absolutely. Now, a job offer letter is exactly the same as an employment contract. It's identical. There's no difference. And both parties have to abide by what that document says. So absolutely. And I haven't read it, so I can't tell you what it says, what it does, if it's enforceable or not. But generally, if you sign a document, both you and the other side have to abide by that document. So hopefully that makes sense. Any questions, you can ask a follow-up question right now. Let's see. James had a follow-up question. James was let go because of his criminal record from 30 years ago. Says American company bought the company and required background checks. So here's the thing, James. I'm not saying they're not allowed to let you go. They are allowed to let you go. All I'm saying is they have to pay you severance. So a company can let an employee go pretty much for any reason, right? As long as they pay proper severance. So the fact that they let you go in and of itself is not illegal, most likely. But what is true is that they have to pay your severance. So it's not a question about did they have a right to let you go. It's a question of how much severance you are owed. So as I said, you connect with me and my team so we can get you that severance, and you can make sure that you don't walk away without what the law says you should have. All right, let's see. Continuing to answer questions. By the way, guys, we have the last 10 minutes or so. That's still plenty of time for you to ask questions. Okay, don't wait till there's a minute to go. That's too late. Right now, you can still type in your question. I can still get your the answer guaranteed here. So let's make sure you get those questions answered with me, Lior Samfiru, the employment lawyer. All right, Henry has our next question. Unemployment made a decision that my workplace was unsafe. I had to work at the company 8 years. Am I entitled to anything from the employer? So I don't think you mean unemployment, probably the Ministry of Labor. No, if you were injured, you may be able to claim compensation to workplace compensation. If you lost your job, then absolutely you're owed severance. If you ended up quitting because the workplace was unsafe, then absolutely as well, you're going to be owed compensation. But if it's simply a situation where you worked there for a bunch of years, even though it was unsafe, that's a terrible thing, of course, but there's no compensation that the law would provide in that situation. Hopefully that makes sense, Henry. If there's a follow-up, or maybe I misunderstood something, ask right now. I'll be happy to provide more thoughts on that. Very, very good question there. Let's see, continuing here. Stevie, next question. Can I record conversations with my boss if I need to? They don't typically email things we've discussed, but I'd like some proof. So the answer is yes, you can. You don't actually have to tell your employer. You can have your phone recording, let's say, in your pocket, and that's absolutely fine. You can record that, and that could be very helpful to have. Now, what you cannot do is record other people having conversations on their own. What I mean by that is, let's say there's two people and you're just going to leave your phone on the table and get out of the room and record other people speaking. That's illegal. That's a criminal offense. Can't do that. But you're able to record someone speaking to you, and you don't have to tell them, and that's fine. That's helpful. Another way, by the way, to do things rather than record is, if let's say your boss says something to you verbally and you think, gosh, I wish I had a proof of that. Well, as soon as that conversation is over, you go to your computer and you send them an email confirming what was just said. Very easy. Just send that email. Hey, boss, confirming that today you said X and Y and Z. That's very helpful. You can do that, but otherwise, yes, you can go ahead and record. No problem whatsoever with that. All right, let's see. Next question from Ralph on YouTube. How long do severance negotiations typically last? 26 years at the company. I'm laid off without cause. So obviously, every situation is different, but on average, they take a few weeks. Okay, so some people are afraid. They think, oh my God, it's going to take years, and I'm going to have to go to court. No, not even close. Nonsense. Not even close. When it comes to getting you the severance that you're owed, in the majority of cases, it's a simple, fast, straightforward process. Okay, we can negotiate that very quickly. Usually they resolve in a few weeks, and most cases will resolve certainly within 3 months, but usually even much sooner than that. Okay, so if we know what we're doing, and yeah, we do, we can resolve this quickly. So what I don't want you to do is I don't want you to be afraid of that process. Okay, I don't want you to be scared of that process. Don't be afraid of the legal process. Saying, well, I know I'm owed more severance, but I think it's going to be a long, complicated, expensive process, so I'm just going to accept my offer. No, please don't do that. In the majority of cases, it's a simple, straightforward process. You don't even pay anything until the matter gets resolved, and even then, a company will pay for it in any event. So don't ever do that. Every day I speak with individuals that call me after they've already accepted their severance offer because they realize they made a mistake and they want to go back on it, but you can't. You can't go back on it once you sign that severance letter. So do the right thing, do the smart thing. If you are let go, you call me. Before you sign anything, before you respond to the company, you call me, we make sure you get what you're owed. And it's as simple as that. So thank you for that question. Let's see. Continuing, a couple more questions here for this session. On YouTube, our next question comes from Francine. My employer has changed my position at work and deemed the position male staff only. I was reassigned into a position that does not meet any accommodation needs. Can my employer do this? So let me just see I understand what you're saying here. So you're a female and your employer says your position can only be done by males and put you in a different position. Well, no, that can't be. That's gender discrimination. There can never be a position that's just male or just female unless by fact that job cannot be done by males. So if your job was to be a male underwear model, well, you probably have to be a guy for that, right? You can't really be a woman modeling a male underwear. So that job is required to be done by males, but that's going to be extremely rare. So what you're describing here could be age discrimination, a human rights violation, not legal in any way, shape, or form. Just like your employer can't say that this position is for young people or for this race or for people that are of this religion. That's illegal. Same thing with gender. They can't say this is just for men or this is just for women. So let's talk about it. That's a constructive dismissal potentially. It's only a human rights violation as well. Not legal, and your employer should not be allowed to get away with it. So thank you for that question, Francine. All right, let's see. Let's see if I can take one more question here. First name, last name had a follow-up. Are those recordings usable as evidence, and is it the same for all provinces? So yes, they're generally usable as evidence. Now, in some cases, someone may want to argue that they're hearsay, but yeah, we usually can get around that and use them as evidence. And yeah, the law would be the same across Canada, across all provinces. Maybe Quebec is maybe different. I don't know. Quebec has their own very different law, so I'm not going to speak of Quebec, but generally in other provinces it would be the same. So yes, it is helpful to have a recording. Oftentimes it could be all the proof that we need to be able to successfully resolve a case or to win a case. So yes, I'm a big fan of recordings. All right. You know what? I'm going to take one last question because I have some time. Just came in from Arch M. My employer has suggested that I move into a new position. It's a step below where I'm at and less pay because my job is being outsourced. If I refuse, is that considered quitting? Well, it depends how different this position is. If it's significantly different, then that's a constructive dismissal. If it's a tiny little minor difference, let's say you were making 80,000, now you're going to make 79. That's not probably going to be enough unless it's going to be embarrassing to take on a new position. Usually, if you're demoted or you're getting less pay, yeah, that could be a constructive dismissal. So that means that if you don't take it and you lose your job because of it, that's not a resignation. That's a constructive dismissal, meaning you're owed your full severance. But before you make that decision, before you do it, I want you to call me. I want us to have a discussion. I want to understand what your old position is, what your new position is going to be, how much the pay is different, how the job itself is going to be different. I want to understand those things. And on that basis, I can tell you if it's a constructive dismissal or not. So do the right thing. Before you tell your employer yes or no, call me. Let's do that properly. And of course, to connect with me, very, very easy. You see that on the screen. You go to employmentlawyer.ca. Again, employmentlawyer.ca. Now, that's the time I have for today. By the way, my colleague, Dan Valkaran, will be back here Friday, 1:30 p.m. Eastern, 10:30 Pacific on Friday to take more of your questions. But if you need my help, my team's help now, before I'm back next week, don't wait. Just go to employmentlawyer.ca. Let's get you the help you want immediately. Asking questions here is fantastic, but the next step is to actually get us to roll up our sleeves, and we can only do that if we connect email or phone, and you do that through employmentlawyer.ca. Guys, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. As always, been a real pleasure to be here with you, to have this opportunity to answer your questions. Hopefully, I've helped a bunch of you today. Thank you so much for joining me. I'll be back next week, but please don't wait till then. Employmentlawyer.ca is the place you go to. Thank you, everyone. Have yourself a great day.